Good afternoon, and welcome back to another edition of NCIA's Industry Essentials Educational Webinar Series. I'm Brian Gilbert, and I'm thrilled to kick off another episode of NCIA's Service Solutions Series today, our sponsored content webinar program, which allows business owners the opportunity to learn more about premier products, services, and industry solutions directly from our network of established suppliers, providers, and thought leaders. In today's program, the team at Fox Rothschild LLP have convened a panel of leading legal experts and regulatory compliance specialists to discuss how agencies and companies can comply when marketing products. As we all know, a successful business relies on marketing and advertising to grow and bring in new customers. But what happens when those promotional efforts are heavily regulated or even restricted? These are questions and hurdles cannabis businesses face, but there are ways to navigate this maze. So sit back and settle in for an information-packed program, providing an analysis of state laws and regulations so you can position your business for success by identifying trends in how cannabis products are being sold and advertised. To kick things off, I'd like to welcome our moderator and one of the members of today's panel to the virtual stage, Joshua Horn, a partner with Fox Rothschild LLP, is going to be kicking off today's conversation with a little bit of background on Fox Rothschild LLP, and then he'll lead the panel through some brief introductions so that all of you all are aware of the background and expertise being brought to today's conversation. So with that, Josh, you can activate your video feed along with Bill and VJ, and you all can join us here up on the virtual stage and get things started.
Welcome, everyone. We're thrilled that you've decided to join us. As Brian mentioned, Bill and VJ and I are from the law firm Fox Rothschild. Bill and I have the privilege of being the co-chairs of our cannabis law practice group. We were the first AmLaw 100 firm to actually have a designated cannabis law practice group. We are chambers ranked, and members of our team are independently chambers ranked, and Law 360 last year was good enough to recognize us as the leading cannabis practice group in the country. And joining Bill and I today is our colleague Vijay Choksi. Vijay brings a very unique perspective to our discussion here today, because Vijay was general counsel in Florida for Grow Healthy, and I think he's got a very unique perspective on these issues because he's been dealing with these issues, as we would say, on both the inside and on the outside of the bubble, dealing with marketing and advertising issues around the country in his role, in that role, and his role that he has now with the firm. And so I wanted to thank everyone for joining us today, in particular to discuss, how you navigate this maze of cannabis marketing. I mean, as we all know, cannabis is still federally illegal, but you still have most of the states in this country have some form of legalized cannabis, either adult use, medical, or a combination of the two, putting aside the fact that you have a federally legal hemp industry as well that gets impacted by these advertising and marketing restrictions as well. And so, I think it's important for the discussion to, put it in context at first, because you're dealing with laws that vary from state to state. And so everyone who's a practitioner or works for a company in the space, and if you're a multi-state operator in particular, you really have to be sensitive to what you're doing in each one of these states. And I wanted to kick off the discussion to throw a question to VJ in particular. How is it, at least in your experience, that you see that marketing and advertising for state legal marijuana companies, particularly Delta 9 companies, not hemp, are different than you would see in other industries?
Yeah, so cannabis is difficult, right? I don't have to say that for anyone. I think we all realize that. But marketing and advertising cannabis is really difficult, right? Because in a sense, there's a lot of state prohibitions that either ban or limit the type of mediums or content that these operators can put forth. So essentially, on a 30,000 foot level, we can parse out some common themes in the type of restrictions that state regulators kind of put forth, right? So can't be false and misleading, can't promote overconsumption, can't have colorful cartoons that appeal to children. And then some states, not all, but some states also get a little bit more nuanced in terms of, for example, New Jersey, and this is the first time I actually seen this, where they're regulating location-based devices, not only on cell phones, which is pretty common, but also augmented reality devices. So we're seeing that state regulators are kind of getting to the trend of new technology. And then we'll kind of understand, how that interacts with, Web3. But nonetheless, a lot of these states, when they are regulating cannabis advertising and marketing, at least from a dispensary point of view, they limit the type of access that marketing and advertising can go ahead and be seen. A lot of states prohibit any type of viewing from public roads or sidewalks or schools and parks, effectively, banning billboards or street signs. And then we're also seeing a lot of, validation data. Where are you marketing? Can you get an audience composition? Is there data back behind that that's saying X percentage is comprised of adults who are over 21? And some states go ahead and actually have like a formal approval process for marketing where businesses actually have to submit to the state regulatory agency for approval what they want to market or advertise. The rules are somewhat a little bit relaxed for non-plant touching companies, but a lot of these rules are also differently enforced depending on the state and even depending on the regulator. Like, for example, in Florida, which is pretty common in other states, you can't have any type of marketing or advertising that's viewable on any public road, street, or sidewalk. But during inspection, we had a regulator come out to a private property, which is the plaza, walking in front of the storefront, and they said that if it's nighttime and I put my head towards the window and peek in, and I turn like this, I could see a little sign, and that's violative of advertising on any public road, sidewalk, or street, right? So it goes in a little bit into the nuances that it's kind of ridiculous when I heard it, but again, it's just dependent on state and regulator how that kind of reacts.
Yeah, that's amazing. It is interesting, VJ, because I definitely think our firm and all of us work in other industries, occasionally alcohol clients, gaming clients, and I definitely think the states view their regulation of cannabis very differently and enact regulations that you would never see in other industries. Some states, I think Montana is one of them, prohibit all advertising for marijuana companies. I don't even really know how you do that, or all marketing, because anything that really has your name or any image or anything is a form of marketing. So, how they define those and enforce those is complicated. In Illinois, in my home state, you have to be a certain distance from like public parks and schools and things like that, which becomes a challenge at times because you have temples and churches and daycare centers and things scattered around the state. Some are licensed, some aren't licensed. It really gets to a zoning thing, but also trying to ensure, who can view your images or marketing, and how you interpret some of these things. One big issue we first had in some states that legalize medical marijuana. Some states have restrictions on physicians advertising to be certified. I think you see that in Pennsylvania, among some other states. So, some states, as you guys all know, come online in 2 steps, sometimes medical marijuana first, then later adult use. How do you get certified as a patient for medical marijuana if you can't find a physician? If a physician is prohibited from actually ever telling anyone on a website, a business card, anywhere that they're offering this service. It really hamstrings folks. And again, you don't see this in other industries. So it presents a lot of constitutional issues that I think we're going to see being litigated as time goes on.
In Pennsylvania in particular, where I reside, bans the medical doctors advertising. And if you're a patient, the only way you can find a doctor is either by the word of mouth, or the Department of Health has a webpage that has the list of doctors. But if you don't know, you don't know. And I wanted to pick up on a point that VJ had raised, is this approval process, because some states have it, some states don't. And what we find is it's kind of ad hoc, where one thing gets approved one day, and then the next day for a different client, the regulator says no. And in Pennsylvania in particular, we've been seeing the regulator taking the position that the proposed advertisement is, quote, too recreational. I have no
I think that
idea
quote's from me. I don't know if they used that quote, but
no. I had
oh, maybe I'm wrong.
yes,
Okay.
no, I had it. I was told it was too recreational. I don't know what that means, because the word recreation does not appear in the Pennsylvania law or its regulations, for example. And Pennsylvania's only medical programs. The only people who can be receptive to this advertisement are people who are certified patients. So whether it's too recreational or not is meaningless. Another thing that we've seen is even though they've approved strain names, now they're requiring the renaming of strains, even though it's a strain, because it's, again, too recreational. And in the proposed final regulations and some of the commentary, the Department of Health has taken the position that if you use a patient name in anything, that's advertising and has to be approved. So that would limit your ability as a business to send an email to a client, to a patient who wants those emails, unless it's approved. Another state that we do a lot of work in, Maryland. Maryland really doesn't have any regulatory environment on advertising and approval, but the statute provides that you can seek an advisory opinion. Well, I don't know what that means. So in one instance, I reached out and I was asked, well, with the advisory opinion you're asking for, do you want a binding or non-binding advisory opinion? And I kind of scratched my head. And what the heck is a binding advisory opinion? Isn't by its nomenclature an advisory opinion something that's just advisory in nature and not binding? So, the key is you have to know your regulator, because whatever the statute or the regulations say, in practice, and we'll touch on this later, is frequently a lot different than what the law or the regulations provide.
It's interesting because it get controversial, but even prescription drugs, or over the counter can still be recreational. I mean, people take contraceptives or Viagra, not just to procreate. It's fun, right? I mean, it's not illegal, and you can still have a prescription that's medically necessary for your bodily functions. So it's really kind of disappointing. The regulators have this double standard for cannabis that's different than other things.
And if you remember some of those ads, people sitting in bathtubs in the middle of a beach and throwing footballs through a tire.
Yeah.
If that's not recreational, I don't know what is.
Yeah. It's interesting because you definitely see the regulators really kind of interfering with the doctor-patient relationship, which is, telling in it from a timing sense, because we're having a lot of discussion in our country right now about bodily autonomy and healthcare following the Supreme Court's recent decisions. So I think while not as extreme and maybe as important, it's still an important issue about people making healthcare decisions, and those being between them and their physicians, without the government imposing its policy. So hopefully with some of the discussion in America right now, so it'll bleed over to these other issues.
On that note, Bill, I kind of wanted to, ask you, as lawyers, we're all lawyers here, and all these state restrictions for marijuana and cannabis, how is it okay under the First Amendment that these regulations are restricting communications? And how is it okay? And are there other similar state constitutional, like free speech protections available as well for a company?
Yeah. I mean, for our day-to-day, working with our clients, I mean, there's always two parts. Clients call us, can we do this? And usually, my answer is, well, you can't under, the regulators' rules or something. But then there's always the other answer, which is, this rule is unconstitutional or not under some First Amendment protections. Because, in my opinion, most of them are. First, of course, you have, the federal First Amendment free speech rights. But then every state in the union has their own state constitution, which has their own version of the First Amendment. So even if one could argue First Amendment doesn't apply, that's federal law, this is illegal federally, there's always the state First Amendment. And generally, in most of the states we've dealt with, the case law says that state First Amendment rights are usually broader than the federal. So yeah, if someone was asking me, hey, are these regulations or prohibitions under the state law, for example, that physicians can't advertise, that medical cannabis marketing has to be pre-approved, we would generally do that analysis. And there is a long litany of cases that have really come down in similar areas in the last 30, 40 years in the US. One of the great famous ones that really sticks out is the Virginia State Board of Pharmacy. As the US Supreme Court several decades ago that had invalidated on the First Amendment grounds a state prohibition in Virginia on pharmacists advertising drug prices. You couldn't put an ad that said, whatever these prescription drugs, so people could shop around. And in that case, the US Supreme Court had held that was unconstitutional. It was not false, it was not misleading. And some of the justifications that the state used was concerns of hyper competition, whatever that means, and that may encourage people to get prescription drugs that they need. Didn't really make sense to the Supreme Court. Doesn't really make sense to me either. But that kind of got followed up by like the seminal case that we as lawyers deal with when looking at these restrictions on speech. There's this famous case called the Central Hudson, another US Supreme Court case that came out later. And they really set out like a 4-part test for analyzing whether a state restriction is constitutional or not. And the 4-part test is, does the speech at issue concern lawful activity, and is the speech misleading? We'll get to that in a second about the lawful activity. 2, does the government have a substantial interest in regulating the speech? 3, does the regulation directly advance that government interest? And 4, is the regulation more restrictive than it needs to be? Basically, are there less restrictive means of achieving it? Now, for us in this discussion, and when talking with clients, the first issue comes up, the first question of the Hudson elements, is the speech, concern lawful activity or misleading? Obviously, if we were in federal court, that would be a big issue. Federal court would say under federal law, it's illegal speech. But, as we know, legalized cannabis in the US is a state-based issue. These things should be in state court. And under state law, if medical or adult use cannabis is legal in that state, then it's legal. So we can really get through all those things. And so that's most of the analysis. Thereafter, the Supreme Court had some cases that really Central Hudson applied these factors to various things. One was this the case called Thompson, where there was an FDA law that prohibited pharmacists who compounded drugs to advertise that they would even do this. Kind of like some of the concerns Josh raised about regulators feeling like too much marketing or any marketing that makes it look too recreational-ish would be illegal. The Thompson case really dealt with that. In that case, the state justification, what was the US government, it was an FDA regulation that prohibited compounding pharmacists advertising. There they were afraid, according to the FDA, that if people advertise stuff, that might encourage people to go to compounding pharmacist drugs and maybe get prescriptions by their doctors for such that they didn't really need. They actually said that in the decision. They felt it would encourage people to get drugs they didn't really need. The Supreme Court resoundingly rejected that reasoning. They're like, first of all, if they get a prescription by a doctor, then obviously the doctor, after an evaluation, feels they need it. And if they're, going to make a decision about their healthcare needs and whether they and their doctor thinks they need it, that's up to them. So, as long as it's legal, it's not false and misleading, all those elements, you can do it. And I think that case really applies to what Josh was talking about recently with some states. I think in that case, Josh was Pennsylvania, because, it's just like Thompson and Virginia State Board of Pharmacy. The state is not the one to determine if a physician and their patient thinks a drug is necessary, or any kind of medicine is necessary, and goes and gets that. And if someone makes a bad decision after seeing their physician and getting a prescription, the state can't really intervene on that. And that's what that court had held. And I think there's I'm sorry if I'm talking run on here, but there's another issue that I think is going to come up in the future, but we haven't really seen yet. that relates to this. And I think that's so-called equal protection challenges, because we know state and federal constitutions require the government to apply the law equally among different players. So, if the government or the courts are going to apply the law and allow these things and these activities to happen for alcohol and prescription drugs, they can't have, or they shouldn't have, more restrictive restrictions for medical marijuana or adult use cannabis like they would in these other industries. And that's something we're seeing across the country, right? States that don't have these arduous limits on prescription drugs and alcohol, but they do in our industry. And it really seems like an equal protection challenge that's brewing for a lot of these issues.
And to pick up on Bill's point, we recently, and I think this is a perfect example. We recently had a client in an adult use state, and who has the dispensary, and adjacent to the dispensary is a park which was having an event in the park. And in the park, there were tents where people were selling beer and selling Delta 8. But yet our client is prohibited from doing that. I mean, that's like the quintessential equal protection type issue. Why is it where our client, unlike Delta 8, for example, is highly regulated by the state, and our client couldn't do anything? But unregulated, people think a questionable product, was fully able to market and sell it as they deemed appropriate, which I think will really raise this equal protection issue as we move forward, particularly as compared to, unless Delta 8, for example, becomes regulated by the FDA, for example, if it's still deemed to be hemp, and under the Farm Bill of 18 comes under the FDA's ultimate auspices if the FDA ever issues its regulations. I mean, it'll be interesting because now, you could go to any street corner store and they can advertise Delta 8 in the window, and 2 doors down, you could have a medical marijuana or adult use dispensary who can't really advertise at all. And so I think it's going to take the right case, but I truly believe, and I think I can speak for Bill and VJ, it's going to be challenged at some point, because at some point it's going to be so restrictive. I mean, who's to say, whether a client or a patient wants to buy something that's called Purple Kush instead of PK? I mean, that's what clients have had to do, is rename their strains with abbreviations, because the regulator says it's too recreational, even though the only people who can buy it are people who are certified medical patients in the program. I mean, it makes no sense from a free speech standpoint. And then as compared to other products, alcohol, for example, other drugs, FDA regulated drugs, for example, free to advertise within certain restrictions, but for the most part in the cannabis space, it's much more limited. So I think there will be these challenges, and I think that they're not going to succeed. I mean, the challenges will succeed. I think the laws will be really taken to task. And in particular, what I find particularly troublesome is this kind of ad hoc decision-making process where you have the law, you have the regulations, and then the regulator says something completely else. And you say, well, wait a minute, that's not in the law or the regulations. And so your choice is to eat crap and take what the regulator's saying, or fight it. But if you fight City Hall, that has its own potential ramifications going forward. So I think it's ultimately going to take an industry-wide group to band together to really challenge these things, because it's really it's hampering the industry from a business standpoint, and quite candidly, it's hampering the ability of people and physicians who want to either direct their patients to use these products or use the products in general, because you just don't. There's a lack of information, and as we all know, when there's a lack of information, there's misperception and misunderstanding, which only leads to unfortunate results.
I mean, just
So Josh, you raised.
pick.
Okay, to add something real quick.
Yes, go for it, Bill.
Oh, real quick. you raise an interesting question with the alcohol being sold at parks, because in Illinois, our statute says that adult use cannabis shall be regulated, or should be regulated, whatever the word is, like alcohol. And so, we have that issue here where you go to public parks and events and festivals, they're selling alcohol, they can't sell or even advertise in any means adult use cannabis. And that really gets us to, if there's ever a court challenge, under the Central Hudson, generally they use what's called a strict scrutiny analysis. The court looks at strictly, and it's hard for states to prove. But frankly, I think someone could prevail against the state on a lower standard of the rational basis test, because it just seems completely irrational. You could sell alcohol, not adult use cannabis, and the statutes say they're supposed to be treated the same. Just want to throw that out there. When that time comes, I think there's some good case law on that.
Yeah, for sure. And it's funny you mentioned that, Bill. And you, Josh, is just the public festival component, marketplace component. You see that with alcohol. You don't really see that with marijuana, but up until recently, California, the California Bureau of Cannabis Control, the BCC, they introduced this non-statutory licensing scheme that actually provided for that legal framework for actual cannabis event sale licenses. So, you could apply for this license with the fee in California, and it would allow you as a license holder to have on-site sales and consumption of cannabis products at public events. Now when they did that, it's really up to the jurisdictions, but we've seen some jurisdictions in California, even San Francisco, that introduced some sort of like pilot programs that actually exist within the framework that California introduced. It's a bit nuanced, but essentially what BCC requires is that every public event that allows this on-site cannabis sales has to be licensed, and you have to obtain an annual cannabis event organizer license. And once you have that license, you pay a fee based on the number of events that you think you're going to go ahead and have. And then when you do have that event, you have to apply for a license for that specific event before it happens, and submit paperwork like a diagram, a layout, written approval from the local jurisdiction, a list of all the licensees and employees that will be selling or handing this out. So, I think California provides a little bit of a framework, just as they did in cannabis nationally. It all started there and then precipitated a little bit to the east. That may be some sort of good news for companies who are not afforded this opportunity to do new types of marketing and advertising that are available to non-cannabis brands like alcohol.
Hopefully that trend will start going east.
Yeah, and it's funny, BJ, because in Pennsylvania, it's almost the polar opposite. I mean, so if you want to have an event at your dispensary, you have to submit an application to have an event. And so, what do you have at an event? You have music, maybe you have a food truck. Guess what? Not in Pennsylvania. They won't let you do that. That's too recreational. And so, so it's like, well, where do you draw the line? It's an event. It's that you have an information stand to talk about medical marijuana. You have maybe a physician there or a pharmacist, but yet, it's too recreational for their taste. And I explored this issue, and I said, well, let's just say, hypothetically speaking, here we are in the city of Philadelphia, and you have a community day event in some section of the city to clean up a park, clean up the trash so kids can play in the park. And if you're a medical marijuana company in Pennsylvania and you want to volunteer as a good citizen, you better not be wearing your t-shirts from your company without getting specific regulatory approval, because they deem that to be advertising.
Wow.
And the way it was explained to me was, well, if you pay a fee for anything related to what you're doing, that's advertising, and therefore it has to be approved. And so, because they paid to have these t-shirts made, or paid to have a website launched and monitored and kept, that's all advertising and has to be approved. And so, where do you draw the line? I mean, it's.
I got another example for the t-shirts. we had a client who got dinged for a T-shirt that had an image of a marijuana leaf, because some states prohibit any images of the marijuana leaf by a licensee or their employee. I don't know how that's a First Amendment thing. I mean, clearly maple syrup people have like a maple leaf or something like that, right? And it's legal in the state. You know, more frustrating is that I, as a non-licensee, I'm not licensed by the state, I can wear a T-shirt with a marijuana leaf. But if I happen to work for a company that's licensed, then I can't. And that doesn't make any sense at all. And the marijuana leaf in question at the time was being worn by a T-shirt by an employee in a marijuana store. And I don't know, and I had looked before this webinar, looking at this in the past, for any case law that ever got to the US Supreme Court on, like, you know, free speech restrictions of images, and there really aren't any. But there was a case or two on the East Coast, actually one was in Iowa, I believe, where some students sued a university because they were prohibited from having an image of a marijuana leaf on, I think it was like some normal event. And the court had held it was illegal restriction on speech that violated the First Amendment. So, you know, I don't know when we're going to get to some of that litigation here, and hopefully we won't. And, you know, the regulators will wake up. Some of stuff just is infuriating.
One question we have that we're kicking around is, we've been talking about adult use of medical marijuana, but what about hemp and advertising for hemp? Because that's a little bit different. And because, as we know, under the Farm Bill of 2018, at least hemp-derived products are subject to the FDA's oversight. And the FDA and the FTC have been sending cease and desist letters to hemp CBD companies around the country because they're touting the health medical benefits of these products, because the FDA has taken the position that CBD is a drug because it approved Epidiolex, a drug to treat two very rare forms of childhood epilepsy. And so therefore, any product that has CBD in it that's being touted as having health curative effects is a drug. And if it didn't go through FDA approval process, then it is false advertising and has to cease. But what is a curative healthcare claim? I don't know.
Well, at least there, there's no equal protection thing because the government's, treating everyone equally, right? So if US law treats advertising and potentially misleading advertising for health reasons, against drug companies, over-the-counter companies like the FDA does all the time. And now that, hemp-based CBD or CBD generally is a drug ever since it was approved by Epidiolex, at least the FDA enforcing the normal customary federal laws against companies making up substantiated claims, at least for, our industry is being treated equal. But that, some of that stuff would pass the Central Hudson test and would not violate the First Amendment, because it is the Central Hudson test, as we talked about earlier, does require the court to ask whether the speech is misleading or potentially misleading. And I know that the FDA in various states certainly regulate and monitor claims by companies as to health and curative effects and whether those have substantiation. And, the FDA sometimes spends, 1, 2, 3, 10 years looking at these things and coming up with a consensus by their scientific advisory panels. And I know they're looking at that. So I do think some of those restrictions, would pass muster to the extent someone says taking this strain of cannabis will cure cancer, for example. I mean, we know it can help cancer patients, but curing cancer is a little extreme of a claim sometimes.
Well, and those types of claims, I think, the FDA, has fodder to go after it. But totally. If you have a product that says it helps with sleep, well, sleep's not a medical condition. So is that okay? I mean, is it okay today? Maybe it's not okay today. Maybe it's okay tomorrow. Does it depend upon who at the FDA or the FTC are looking at this form of advertising or packaging that has this claim on it? I mean, you have the obvious, it cures cancer, it cures migraines. I mean, people were marketing that their product prevented COVID. That's low hanging
If
fruit.
only.
Right. I mean, that's what I would characterize as low hanging fruit for the regulator. But I mean, Vijay, what do you think? I mean, having been in the industry, where's the line?
I think it just goes towards, are you making a therapeutic claim? For your example was sleep. I would say that, yes, I would advise that we don't do that, right? And it's hard because the hemp industry is so saturated with so many players. How do you distinguish your product from everyone else's product? When someone asks you, hey, why is your product better? What do you say? I mean, you can't say much. You can't say that, oh, we've got an extended release. That's similar to a drug. You can't say prolonged effect. You can't say fast acting, long lasting effects. It's very difficult from that point of view. But not only that, how do you market it? Because, not only what you put on the label matters, what you put on your website is an extenuation of your label. What you tweet out is also an extenuation of your label. What you post, what you link to. You're even responsible for, user-generated content on your messaging boards. There's the gamut of so much things you have to draw your attention to. It gets kind of daunting, especially operating in a saturated market. That's also more cumbersome as well. So, it's hard to be a hemp company today and distinguish yourself.
Yeah, no doubt about it. Yeah, I'm sorry, Bill. Just one thing that Vijay raised, and there was a cease and desist letter that went to a company, not for statements that they made on their webpage, but the reposting of people in the public domain who love their product and posted on somewhere on the internet, and this company then just did a link to those posts onto its webpage, and the FDA said, you're touting health curative effects for your products, cease and desist.
Well, that's an important message for our clients. Really be careful what you link to and things like that. That is surprising.
Yeah, you just don't know what pile you're going to step in.
Well, some of the marketing things we see people doing with some things, like Vijay, you bring up, of course, valid points about, you can't necessarily say these things, but, people are being very creative with their marketing, especially with, cannabis for sleep. I see a lot of, because you can't make those claims. There's other things you can do. You see people adding, melatonin. Maybe they have a gummy that's got a little melatonin. It's got some chamomile in it. And then, of course, it's got an indica strain that helps people sleep. And, there are certain things you're allowed to talk about with like over the counter or nutritional supplements. You can talk about these other ingredients or tout it. The sleep example is just a great one because in Illinois, I see a lot of cannabis products in the market for sleep. Great packaging, gummies that are delicious because you think about taking your melatonin pill, it's not a little snack before you go to bed, right? But some of these gummies are, and having melatonin included in those other things really helps distinguish your product from other products. People are familiar with, those other things. Like I said, chamomile, valerian root, and you add those things. It gives people more of a comfort and familiarity because they've seen these products over the counter, without the cannabis added to it for decades.
Yeah, and I mean, also, to your point, like you said, melatonin, lidocaine, chamomile, people know that that nomenclature and what that effectively would do for them. Another thing, not to harp on the negative components, but like, what can you do as a hemp company to distinguish yourself? You would be able to say something along the lines of, say, pesticide-free, or non-GMO, or natural, or organic, assuming you have your documents to back up whatever you're claiming. You can't just say, well, I'm going to say all natural. Well, no, there's rules against that. Do you have documentation and audits to substantiate what you're putting on your label? That's important. And then for companies who want to stand out and want to put that nomenclature, like kosher, for example, invest in those type of distinguishing nomenclature tags that you can put on to your guidelines or collateral.
You better have a rabbi standing by if you want to say it as kosher.
Yeah.
But Vijay, all great points. I'm sorry, Bill.
No, I was gonna say, I mean, I got a great example for what you're talking about with the dossier. We had, you know, some clients who have had some state district attorneys look into some claims. You know, we all think about the FDA sending cease and desist letters, but I've seen in Illinois and some other states where states attorneys, district attorneys actually have, like, to our surprise, you know, groups that are looking at some hemp-based claims, not attorney general, not FDA, but more local prosecutors. It's coming on, drawing their attention. And, you know, we've seen some clients have to respond to requests by these prosecutors to substantiate and document their curative health claims like this. And when you're going to make advertising, it's going to have some of that, you know, in-house, you know, thinking as the marketing person has, you know, what do we have to back this up? Are the third party, you know, journals that have reported on this? Who said that? And kind of have that in the file. So if you get a request that says you got to respond to this in like 5 or 10 days, you guys really have some backup, like you said, dossier for your claims. It certainly, you know, makes it better. Now they may disagree with those claims. It may be that a prosecutor as an expert is going to counter them, but just the fact that before you made the claims you had it really helps you a lot. And I find that some of these prosecutors more local doing this, frankly, I think sometimes it's just a shakedown for fines and settlements, but something people should be aware of. It does happen. People are not advertising it, but it is happening a lot.
So let's change gears a little bit. So, you know, we've been working with state and federal laws on marketing restrictions, but what trends, let's start with you, Vijay, what trends and challenges you see for cannabis products that are being advertised, such as, for example, you know, loyalty programs, HIPAA issues, privacy issues, IP issues, you know, advertising in one state so somebody can go to another state to get products they can't get in the state where the advertising is. I mean, what's your sense of what you're seeing in the marketplace?
Yeah, so, you know, what I'm starting to see a lot of is how do we avoid these marketing and advertising rules and regulations? Not avoid it completely, but how do we, you know, take a good faith effort to get our brand theme, our brand voice? How do we share it with more people, right? So what I'm seeing a lot of are companies setting up separate entities, just completely that are non-plant touching entities, just for like merchandising and apparel. And essentially what that does is it allows these entities access to traditional marketing vehicles like Facebook AdWords, Facebook advertising, Google AdWords, that are traditionally not really available to regular cannabis plant touching companies. You know, case in point, you know, you're seeing a lot of West Coast brands that have proliferated east who've adopted these same type of strategies where they're able to go ahead and run ads on t-shirts and mugs and things of that nature, and also get that IP protected under USPTO, but not only that, but also state level as well. So that's somewhat of a trend that I've seen. Another trend that I've seen here is the advent of loyalty programs. And you got to be kind of careful with that depending on what type of market you're serving. Are you serving an adult use market, which are consumers, or are you serving medical markets, which could be patients? And if you're dealing with the latter, patients, you know, you have to kind of evaluate your state regulatory regime to see, you know, does HIPAA apply to you, right? And if HIPAA does apply to you, you know, how are you going to be using this protected health information, this PHI, to your advantage to retarget your patients for purchases? So, you know, there's a lot of power with a loyalty campaign in targeting your consumer base or your you know, clients or consumers or patients. But, you know, with that, there's a lot of rules and regulations. You know, when you do have a loyalty program and you collect these data points, how can you use these data points? You know, you could say start emailing, right? That's a good way to kind of target. And what I've seen a lot of cannabis companies do, quite honestly, is just engage in email marketing campaigns. But when you do that, you know, there's certain regulations that you have to abide by as well. Case in point, you know, CAN-SPAM Act. right? That kind of regulates emails. You got to ensure that it's not misleading. You have your address on there, and the list goes on. But yeah, those are just some high level trends that I've seen that kind of work here in the cannabis space. And then just to add one more thing, trends as it currently exists, but what are the trends out into the future, right? What happens in 2023, 2024? And I think, that's where Web3 comes into play. I know it's like a buzzword now, but we could see cannabis companies enter the metaverse, whether that be Facebook's metaverse or some other iteration of the metaverse that's only for cannabis companies. I think that could be a good touch point where cannabis companies can kind of flourish a little bit.
Yeah, you raise a good point about the HIPAA, because we've dealt with that with a lot of clients, and there's a lot of questions, not so much these days, but going back 1, 2, 3 years, whether, federal HIPAA privacy laws for healthcare information, apply to medical marijuana. And a lot of people assume it doesn't, it's illegal federally, so who cares? But a lot of state regulators have made it quite clear, either directly in the regulations or telling people, it does apply. And even if it doesn't, we have a state equivalent. Illinois, they have that specifically in a regulation that federal HIPAA law applies. And it's important for marketing, because if you're going to have loyalty programs or people sign up for text for sales, whether in this medical cannabis, you really need to make sure that when customers sign up for these things, you have a proper release. You can market patients if you have a proper and full release in advance that complies with HIPAA. So, it's just, one of those things, you buy software or something, you got a click box or something, but make sure that you get that done and you keep track of it for individuals. Another thing, BJ, relates to that is, with medical cannabis and these HIPAA things, if there's ever a data leak or some accident happens like that, HIPAA requires you to have like a plan to notify people and try to fix it. So it's not too arduous, but it's something definitely to look at, talk with your in-house lawyer, outside lawyer, how to do this, because you really protect your liability. In the long run, it's in your best interest.
One of the things that I think is really becoming a tremendous minefield in the advertising space, and picks up on a point that VJ was making about loyalty programs, and that is the Telephone Consumer Protection Act. And those of you who don't know what it provides for, in essence, you are prohibited from texting individuals marketing material unless they give you express consent. And so people may say, well, why the hell should I care about that? Well, the penalties available on a TCPA violation are $1,500 per violation. So let's just say, hypothetically speaking, you're both a medical and an adult use dispensary, and you have 10,000 customers. Okay, you're very successful, and you're like, well, I have their cell phone numbers, and I'm going to, email them all, text them all. I'm sorry, a discount program. Well, do the math. That's a big number.
Doing it in my head, that's a lot.
I think I need an accountant. But so there's just tremendous,
and it's strict liability. There's no excuse. Doesn't matter. It happened. You didn't have release.
Exactly.
Doesn't matter if some 13-year-old grabbed your phone and did it. Strict liability.
There is a very large plaintiffs bar out there that focuses on TCPA, and I guarantee you the cannabis space is a target. We've seen cases already, and I think the reason why they particularly see cannabis companies as a target, because most companies, there's a lot of difficulty getting insurance for these types of violations to begin with, and even more difficult for a cannabis company. And so, the plaintiff's bar sees that as easy money. And so, don't make it easy for anyone. If you want these loyalty programs, you want to text people, you have at your point of sale, you have people check a box that gives express consent to accept marketing materials via text. And it's not that hard to do, but it's very easy to not do it. And the ramifications are just tremendous. I see we're running up against some time. I think Jason Dreyer had an interesting question, Bill, and I think maybe this is more directed to you because you're admitted in both Michigan and Illinois. And so when he was in Michigan, he saw cannabis billboard advertising, but hasn't seen that type of advertising in Illinois. I was curious, is there, even though Illinois has got medical and adult use, what's the deal basically?
Yeah, well, basically there is some billboard advertising in Illinois. Actually, if you're like on the Edens going towards Chicago, you would see a few for some dispensaries. It's interesting because the different states, and I don't have Michigan memorized, but in Illinois you can't like promote consumption, you can't have pictures of the cannabis. So one company, I think it was Rise, had a billboard not too far from me by a highway that said, Rise, where America shops for like cannabis or something like that. It didn't really say buy it here, consume it here. It just made people aware that the place existed and had an address. So, there was obviously the company put some thought into what they could do and had a great ad, and everyone saw it. It didn't promote anything, but you knew there was a dispensary and it had the address. So it was very effective. So it's that nuance thing. And then people have been having ads in some other states. I heard, I haven't seen, that there were ads in Missouri, billboards that try to get Missouri folks to come to Illinois to buy adult use cannabis in Illinois. And that's interesting. I mean, and I hadn't seen it, I just heard it because I was really thinking about that with what we were talking about, the Hudson factors. If a state, let's say a state that did not allow cannabis, let's take Indiana or something like that. I want to have an ad at the border telling people, come to Illinois and buy adult use cannabis if you live in Indiana. I think the state could restrict that because, one of the analysis of the first Hudson factors is it legal activity. Now in the state of Indiana, it would be illegal activity. So I think they could prohibit a sign saying come to Illinois. But, cannabis is expensive in Illinois and it's cheaper in Michigan. So I think you could maybe have an ad in Illinois for a Michigan company by the border saying, hey, just drive another, X 30 minutes, come to Michigan, buy cheaper pot. I think you could do that probably in Illinois and it would survive a constitutional challenge. So there's that out-of-state nuance thing, which gets a little weird. But I think a billboard would be the same analysis of whether it was a T-shirt or not.
VJ, I have one last question. We're up against our time here. The question I have for you, and picks up on a lot of the points you were talking about just earlier. I mean, what about like leaf or weed maps? Or is that basically a way around the regulatory environment for advertising for these cannabis companies?
Yeah, so companies like marketplace sites like these sites have that audience composition data that allow them to geo-target specifically to that jurisdiction, right? So you'd be able to still stay compliant, and it really depends on your state. For example, in Florida, we have Weed Maps and Leafly, but OMMU, the Office of Medical Marijuana Use, put out a decision that stipulated that Leafly was prohibited because companies who utilize Leafly for in-store pickup now relied on a third party for direct dispensation activities, which no one else can do besides a license holder. And Leafly had a big portion of the Florida market. And of course, they didn't agree with that, hence they challenged it. And since that challenge, and about, I want to say a little less than a year thereafter, OMMU reversed track and then now permitted cannabis license holders, at least in Florida, to utilize that in-store pickup option. And it was a bit of a conundrum because in the sense, you're relying on the third party now, to not only facilitate that transaction, but to collect PHI because Florida is a medical state.
Public health information,
yeah,
or personal health information.
Yeah, right. So that PHI, the protected health information, was getting aggregated by a third party company. So that also brings up another point. If you are relying on third parties to aggregate data, store and transmit that PHI, you need to ensure that you have them execute a proper business associate agreement in place, assuming that you are under the guise of HIPAA, or you believe you are under the guise of HIPAA.
And get indemnity.
Yeah, and those BAAs, as they're called, for those who don't know, like I said, are required under HIPAA law. So if a hospital is using a third party to supply their cloud computing or something, they have to have an agreement that the hosting company is going to comply with HIPAA just as if they were a hospital, right? So it's everyone that you're dealing with, which may touch this information, I believe under HIPAA, you're required to have that agreement.
All right, everyone. Well, I wanted, on behalf of Fox Rothschild and VJ and Bill, I wanted to thank everyone for participating today. Hopefully, you got some better understanding of the maze that you all have to deal with on a daily basis. And feel free, if you have any questions and want to follow up, reach out to any of us. We're happy to field your questions, and wish everyone well and stay healthy and stay cool. It's pretty hot out there right now.
Thanks, Josh and VJ. It was fun.
Thank you, guys.
Fantastic. Well, thank you so much, Josh, Bill, and VJ. That was an incredibly informative conversation. As I said a few times in the chat window, I learned a lot myself, even some of the nuances that you dove into, specifically around those consumption events in California and the text messaging opting in were all issues that NCIA has had to navigate ourselves over the last few years with some of our nationwide events. So I really appreciated you all digging a little deep into some of the nuances there. And thank you so much for addressing those questions from the audience. As we mentioned at the top of the hour, we really want all of these experiences to be an interactive educational experience for our participants. So I really appreciate you all diving a little bit deep into those regional specifications for some of those things in Illinois and Michigan, and all of the nuance there. So thank you all so much again, the team from Fox Rothschild LLP, for presenting today's program, Taking Your Profits Higher, Navigating the Maze of Cannabis Marketing. Stick around for a few more minutes, interact with the panel inside of the chat room. If you have any outstanding questions, as I mentioned in the chat room, don't hesitate to post them to the Q&A board now. Our panelists might have a few extra tidbits to share while we're closing out today's program. And then any outstanding questions that are still outstanding following the broadcast, we'll use those as fodder to carry on the conversation first inside of our members only community platform, NCIA Connect, and then secondly on the published public blog that'll be posted to NCIA's website with the formatted recording of today's program later in this week. And with that, thank you all so much for participating in another NCIA Industry Essentials educational webinar. It feels really great to beat the heat together while engaging with our network in a live format. So we sincerely hope that you'll continue your participation with all of these interactive educational opportunities throughout the remainder of this summer. As I posted in the chat room, we do have a relevant program that's going to be diving a little bit deeper into Michigan regulations surrounding cannabis consumption lounges and temporary cannabis consumption events, headlined by the head of Michigan's Cannabis Regulatory Agency, Andrew Brisboe, taking place on August 16th. All of you all will be redirected to the webinar archive following today's program. So if you are wanting to carry on the conversation surrounding some regulations as it relates to marketing, cannabis consumption, and events, we would love your continued participation with our webinar program and hope to see you there next month. If you haven't already, make sure that you are signed up for our weekly Events Digest newsletter that goes out every Monday afternoon. That will keep you up to speed on all of our activities as soon as they're announced, and provide supplemental resources to make the most out of your involvement with all of these educational sessions. Huge thank you once again to the members of our panel for presenting today's session, Josh, Bill, and VJ, along with all of our audience members and member business owners, which are essential in driving our organization's mission forward. As always, we'll leave you all with this end of event credit sequence, highlighting those member businesses that participated in this afternoon's session alongside our Evergreen Roundtable. If you don't see your company included in the slideshow, don't be discouraged. That just means you need to head to the cannabisindustry.org/join following today's program to join the movement for a responsible and equitable cannabis industry. We hope you enjoy, and we'll see you all hopefully again next week for another NCIA Industry Essentials educational webinar. See you all then.